So the lease just ended and it's time for everyone's favorite dance, the security deposit release dance. Today on Managing Manhattan, we're going to talk about the rights and obligations of landlords and tenants when it comes to the release of the security deposit. Today's guest is Josh Kopelowitz. He is the co-chair of Real Estate Litigation for Fox Rothschild. Above that, he was also super lawyer for New York real estate from 2019 to 2025. He's listed as notable litigators and trial attorneys by Cranes New York, Chambers USA list of rank attorneys for real estate litigation, and is also Martindale Hubbell AV preeminent ranked. Josh, welcome to Managing Manhattan.
Thanks for having me. It's quite an introduction. Makes me seem like I know what I'm talking about.
Yeah,
so
it definitely justifies those large bills we get for you. That's for sure. with these kind of credentials.
Yeah, that's right. I'm not charging you for letters. I'm just charging you for the letters after my name.
Perfect. Please don't charge us more though. After reading all these accolades you've amassed, it's making me a little bit nervous for my next
I'm happy
bill.
to be here. I can't wait to have this conversation. I know it's something that everyone's curious about. So let's dive in. Where do you want to start?
Absolutely. So look, the security deposit topic seems very basic, but as a landlord who does this so much, there's so many intricacies to the law and gray areas in how things should be done, when they should be done. So we want to kind of give more insight to our viewers on what the reality of the situation is and how do we decodify these gray areas and how to deal with them. So I want to talk, first let's start with the basics. In New York State, how long does a landlord have to return your security deposit?
So I think the basics is the best place to start. And I'm going to answer your question. It's 14 days pursuant to General Obligations Law 7-108. So GOL 7-108. But I think it's
Look it up, guys. What's the ranking?
GOL 7-108. That's a free one, no charge. But I think it's important to understand why that law came into place. So before 2019, there was no specific law about the return of residential security deposits. It was governed by case law. It was governed by the lease. And it was really just sort of something ephemeral that was out there that you couldn't touch. And residents were always complaining that their security deposits were not getting returned timely, were not getting returned at all, and the like. And finally, that voice got heard to the point where they passed the law, GOL 7-108, that requires landlords now to return the security deposit within 14 days of the tenant vacating. But it also, of course, as I'm sure you're going to ask me and it has a lot of other regulations and obligations on behalf of the landlord that they must fulfill, notwithstanding that it's the tenant's security deposit for there to get back.
Right. And when they say 14 days, is that business days, calendar days, do federal holidays, are they included in there? Because look, I totally understand the intention of the law. There was a lot of bad behavior from landlords. We had reasonable time to give the deposit back. Everybody had a different idea of what reasonable meant. Some landlords thought 30 days, some landlords thought 60 days. So I understand why they capped it, although I think it should have been 30 if we could go back and read the law and I were in charge, but unfortunately I'm not. But how do we determine what the 14 days are? If you move out at 6 o'clock on Friday night,
it's a great question. And the answer is no one has the answer. This law was passed in
typical lawyer response, guys. Typical lawyer response.
The answer is the law was passed in 2019, and then unfortunately COVID hit. And there just aren't that many cases that have been litigated to the point of decisions to answer this question. And in fact, I just looked it up the other day, and there are only 36 reported cases with respect to this law, and that's over a 6-year period. That's just not enough.
And that's because they don't make it through, right? Everybody kind of drops out.
Correct.
If you decide you're going to pursue, you probably back out because it's not enough money to
It's just not worth it, right? People make a cost-benefit analysis. So the answer is I don't know. But what I will say is look at your lease and look what the notice provisions in your lease say. If the notice provisions in your lease say this is deemed served X days after mailing, well, you need to take that into consideration. And I would say that the courts, which generally tend to side more equitably with the tenant than they do with the landlord, not mad at my judges, just saying that sometimes they give the tenant benefit of the doubt. They're going to look at that lease and say, oh, well, it says it's deemed delivered 5 days after mailing. So now you've just cut my 14 days into 9.
Right.
And there is a general obligations law 7-103 that says if any deadline falls on a weekend, it kicks over to the next business day. So that would help a landlord. So if it falls on a Saturday, it kicks over to a Monday or the like. Just like in the lease when it says, hey, if your lease expires on a Saturday, that kicks over to a business day, typically in the REBNY form. It would be the same thing here. I think the good rule of thumb with returning a security deposit is be reasonable, be realistic. If you send it back to the tenant on 14 days and it gets there on the 19th day because of 5 days from mailing, I don't think a judge is going to really bang you. And if they do, that's not that shouldn't be the norm. The norm should be that the landlord should get the benefit of the doubt to the extent they're trying to comply with the law.
Right. And look, a lot of tenants will try and threaten you with it. Oh, it's past 14 days, but there has to be some sort of reasonable period. Now, what exactly can we deduct from the deposit? Because there's all this ambiguity, and we have all these cases where, you know, landlords want to deduct things maybe they're not able to deduct or should be able to deduct. So from your perspective, what exactly can we deduct from the deposit?
Okay. So now you're asking the biggest question of all, and we're about 3 minutes in. So I don't know how long you want me to go on this, but the answer is nobody knows. All right. There's a former script writer named William Goldman in Hollywood, and he used to say nobody knows nothing. Same thing here with what's a reasonable wear and tear versus extraordinary wear and tear such that the landlord gets to keep it. Nobody knows. It's all based on case law. And
and we'll get to the wear and tear part shortly, but I'm saying, you know, unpaid rent, electric charges.
Oh, I'm sorry.
You know, and well, I do want to talk about wear and tear because that's the crux of what I really want to discuss here. But, you know, oftentimes I'll have a landlord that said, oh, well, they had a dog in the apartment and I told them no dogs. Can I deduct for that?
Okay.
Or another big thing that we come across a lot is the tenant in our leases is required to allow showings 60 days prior to expiration on reasonable notice. They agree to it, and then it's time to show. No, you can't come. My baby's napping. I have a headache. I worked late, whatever. Like, so outside of, you know, damages, which we'll discuss, what other things are we legally allowed to deduct?
So this is where it becomes very important to have good management, like yourself, or a good broker, like Brown, Harris, Stevens. You need someone on the landlord side to make sure that your lease says all the things that you're allowed to deduct. And you're better off being broader than being specific. So for instance, rent, it's typically in the lease that I'm allowed to deduct your security deposit if you fail to pay rent. But you don't typically have something about showings.
Right.
And you don't typically have something about dogs.
Well, we do have things about, let's say we do have something about the showing, because I think even in the REBNY standard form, there may be language that we can do.
You're misunderstanding. Okay. So allow me. In the REBNY standard form and in all the leases, it typically says I can show the apartment X months before vacater. Or before it expires. But there's no penalties involved other than you're in default of the lease. And so what landlords are now tasked with doing is making a choice. If, for instance, using your example of showing the apartment, do I send a notice to cure and default them for not allowing me in? Or do I try to sue them, right, to get an injunction for a court to require them to let me in? And you've come up with a third solution, which I think is very smart. I don't know if we can use it, but I like it, which is work in a damages provision. If you don't allow for showings, I can deduct $50 from your security deposit or $100 from your security deposit. So it's a damage not unlike rent, not unlike additional rent. That may be something to explore. That's a very good idea. And I have to tell you, that's not an idea that someone's brought up to me before.
And there's probably no case law to support it, so this would be a good way of making case law.
I have never seen it. I've never seen it. I've never heard it. I like the idea. But the more you can... You have to be careful. You don't want to monetize every damage because some damages you're not going to be able to monetize properly and you could be cutting off your nose. But something like a showing, I think you'd easily monetize that to a $50 or $100, whatever the cost is of the broker having to come, not being allowed in, rescheduling, reposting. I think that's something that you could probably monetize, and then you can decide to include that in the lease. That's a very good idea.
Yeah, because look, from my perspective, the landlord would have damages. If you don't allow us to show the apartment and we can't find a renter to come in right after you leave, I'm losing money because my property is unnecessarily sitting vacant. So, and it's a question we come across a lot. So I think including a damage provision might be worth trying because I do have damages. You didn't let me show. The broker couldn't rent the apartment, and now my apartment is
no different than a late
vacant.
fee, right? The late fees, they changed the late fees in 2019, as you know.
$50.
$50. But how is that any different?
Yeah.
Right? This is $50 because you don't allow for a showing. It's the same type of thing. That's a very smart idea. I like that. I hope no one steals it, but I like it.
I hope you make case law on it and you win. All right, we're going to take a short break and we'll be right back. Hi, I'm Dylan Pichulik, CEO of XL Real Property Management, New York's most trusted name in luxury property management since 2012. We specialize in managing individual apartments, townhouses, and rental buildings held by absentee owners. We maintain our properties with the highest standards of quality and service, so that owners can choose a hassle-free approach to real estate investing. Rented or owner-occupied, we handle it all. For more information, contact us at xl-rpm.com.
What do you really need to know about buying or selling a home? First, it's serious business. And it's complicated. There's a lot of money on the table, and emotion too. You need an agent who knows the ropes. So, whether you're buying or selling your home, work with professionals who have a mastery of the craft.
I'm Brian Scott Cohen, one of the top loan originators in the country, and the #1 mortgage originator at Guaranteed Rate Infinity. Guaranteed Rate Infinity arguably has the most advanced tech in the industry. Our completely digital loan process makes it easy and efficient for homeowners, from a 15-minute pre-approval to the digital application and through closing. My team and I would love to help you get into the home of your dreams.
All right, we're back with Josh Kopelowitz. We're talking about the security deposit release concepts when it comes to renting out apartments. So we're talking about what deductions we can make, and actually we just brainstormed this great idea that we should have a damage provision in a lease if a tenant, for example, prohibits showings while they otherwise agree to. And you're saying that we could do it, but the rate must be reasonable.
I think it's. I don't know if we can do it, but I think it's certainly something we should consider, and I think it is doable. I haven't seen any case law or statute saying otherwise, and the examples that come to mind are losing your fob or your pass to get into the building.
Right.
You have to pay to replace that.
Yeah, it costs me $100.
Right. Whatever the cost is that the landlord has to pay, you have to pay it because you've now made the landlord incur damage it otherwise wouldn't have incurred. No different than when you're going to try to show the apartment and you've spent your time, you spent phone calls, maybe you made some pamphlets and other things. It's no different than when a plumber comes to the apartment and now the plumber has to leave because you don't.
Yeah, and he still dings me $250 for travel time. But yeah, I mean, there's a direct damage to this one because if you don't let me show, I can't rent the apartment. Therefore, when you leave, I don't have an incoming tenant and I lose. I vacancy loss.
It's opportunity costs.
And opportunity costs.
Essentially. So I think it's a really good idea. I think it's something that we should chase down, and I would not be surprised if I put it in my next lease.
No, let's talk about it after this because I want to see what you write. So I want to talk now about a very important concept, and this is the dance part of this, and that's over wear and tear. And nobody seems to have a straight answer over what wear and tear is. We're allowed to deduct it in the lease. It says we can deduct above standard wear and tear, but how would you define it in a world where it's not really definable?
Right. So we already said you can deduct whatever the lease allows you to deduct, but now it comes down to what about the apartment? The floors, the walls, the ceilings, the lights, the oven, and the like. What's reasonable wear and tear and what's extraordinary? You'll not be surprised to know that there is no bright line rule in the statute. There's no bright line rule in the cases. And so as I stand here today, or I sit in a very tall chair today, I'm going to tell you there is no rule. But the cases do give us some guidance. And we've looked at the cases, and you and I have looked at the cases. And they're interesting. It depends on the judge that's sitting there. Did they have a good day? Did they have a bad day? Have they ever lived in a rental? Do they understand what security deposits are about? Because wear and tear is sort of like what Justice Potter said about pornography. I know it when I see it, but I can't describe it. And the courts have made it the same way. They're saying they know it when they see it. So you and I discussed, what do you use? You say anything above a nickel hole or any quarter?
Yeah, for wall damage, we say any holes above the size of a nickel, we consider that, outside of wear and tear.
Right, and I would agree with you because if you're hanging a painting, like, there's a beautiful painting behind you, that's a pinhole.
Right.
And you put 2 pinholes on either side. We've all hung, hopefully you're doing 2, because if you do 1, you're just going to be fixing it all the time.
Yeah.
So that was the best advice my dad gave me when I moved to the house. Put everything on 2 hooks.
Yeah, so it's not
cattywampus. Exactly. That's easy. I can just spackle that. But let's say you put that TV up. If you do it without landlord's permission, you better restore that wall. That's a giant TV. It requires a rack behind it, right? And you're going to make holes that are certainly bigger than a nickel. They're going to be bigger than a quarter. It might be bigger than a silver dollar.
Right.
And you need to restore that. And if you did it with my permission, then I'm the landlord. I'm going to tell you have to restore it as a condition of putting it in. So either way, it's landlord be reasonable. Now, will the courts be reasonable? That's
another question.
That's another question.
But are you going to sue? But also, let's say I deduct for, like, how do I make that deduction? Because if you put and let's forget the wall example because I'm probably going to paint the apartment anyway. Let's talk about floor scratches.
Sure.
Inevitably, the chair's going to scratch the floor. There's going to be some minor wear and tear on the floor. How do I define what's regular floor scratch versus what's outside of the ordinary? Is there a length guidance that we should be using? Is there a width guidance? Because if you take a chair and you drag it across the floor and I've got a 2-foot long scratch, like I've got to fix that.
Yes. So there is no answer that is specific, but I'll give you my answer, which is it's more than de minimis. And de minimis to me is you're talking about maybe an inch. Anything above an inch is no longer de minimis. And I'm not just grabbing that out of thin air. I'm using it based on case law and experience. So I had a case where believe it or not, a grandson sued his grandma because he tripped.
Poor Bubby.
He tripped and fell into her house on a carpet because when you go from one room to the other, used to be a saddle, but sometimes they're not, and the carpet was an inch high than the hardwood floor. Tripped and fell. Court said de minimis. Anything inch or below, too small. I use that as, by the way, he lost. I use that as
got thrown out of the will.
I use that as my barometer. If I have someone, it depends on how long have they been living in the apartment, how have they treated the apartment, what does the apartment look like, and do I have a renter coming? The new law, GOL 7-108, and I say new, it's not so new anymore, but as a landlord, we are required to invite the tenant to inspect the apartment before they rent it, to inspect the apartment 14 days before they leave, and give them an opportunity to cure. If I'm the landlord, on that 14-day inspection before they leave, I'm making sure that I offer it. And if they don't want it, that's fine. That's their choice.
Right. But we have to offer.
But we have to offer.
Landlord has to offer. They don't have to.
Correct.
It's not the tenant obligation to request it. Landlord has to offer.
Correct.
Okay.
Again, correct. Because, and this may get me a little trouble, but we are in a society that infantilizes the tenant.
Right.
And they make everything the responsibility of the landlord. So, for instance, even though the lease expires on whatever date, December 31st, we still have to remind the tenant, little Johnny, that the lease expires, so we have to send a 90-day notice. Well, it's the same thing with security deposit. We have to invite the tenant to inspection. If they say no, then they take their life in their own hands, and we inspect the apartment when they leave, and we make the determination, and we return the security deposit, whatever's left, within 14 days. If they say yes, then, for what I tell my client is point out every single thing that is wrong with the apartment that is new, because that's not reasonable that the apartment, for instance, if we have a tenant who's been there for a year and there are giant water stains underneath every plant in the apartment, that's not reasonable. They should have just put a dish underneath the plant. Right. And I would say point it all out. And if I have to replace a tile, or if I have to replace, they should pay for that.
Right. Now, here's a bigger question, because we get this a lot in floors, and we actually had a very unfortunate litigation with a very well-known pop star over a scratch on the floor, because the tenant acknowledges they left a big scratch on the floor, but our issue as landlords is if you scratch our hardwood floors, I can't just fix the scratch.
You have to buff out the whole thing.
I've got to sand and stain the entire floor. Can I hold the tenant accountable for that? And literally, this is one of those cases where we advise our client, I don't know if the juice is going to be worth the squeeze. Let's try to make a deal. But they were hell-bent on pursuing this litigation over basically $20,000. And it didn't end up going all the way to court. It went to court, but it wasn't, decided on by a judge. But her point was, it's not fair. I scratched the floor, but I don't want to pay to redo the whole floor. But I have no choice as a landlord. If I just fix the scratch,
I think that's right.
It's going to look touched up.
I think they're both right, unfortunately. I tend to side with the landlord because the scratch wasn't there before I rented person X the apartment. And now the scratch is there. And unfortunately, the only way to fix it properly is to redo the floor. And so I feel for the tenant there.
Yeah.
But
at the end of the day, we have a cost.
At the end of the day, you scratch the floor.
Yeah.
Put a little stopper on the bottom of your chair.
Yeah.
Or
in this case, stop drinking.
Yeah. Well, I'll leave that one for you.
But it's unfortunate because look, some of the apartments that Excel manages are $30,000, $40,000, $50,000, $60,000 a month. It's not like a rental where people let things go. If I've got a big gouge in the floor, our incoming tenant expects it.
And I think that's what's important is that the places, especially that you rent, that are very high-end places. And the court should acknowledge that. And I would think the court would acknowledge that. Because when they went in, they weren't going to accept it if there was a scratch on the floor to begin with.
Oh, no. They would have like maybe paid for a hotel while I fix it. They would have emotional damages, you know.
So I'm not going to allow my client to accept it with a scratch on the floor. I mean, it's the same thing when people have dogs. I have a dog. We love dogs. Right? Pet hair gets everywhere. Will a judge tell you that pet hair is reasonable or extraordinary? I think a judge will tell you it's probably reasonable, but I would disagree with the judge.
Correct, depending on the amount, because it says specifically in the lease, you've got to leave it in broom swept condition.
Exactly.
You're expected to do that. Now, what are the penalties? What happens? Let's say I'm a landlord. I didn't return the security deposit in time. You know, let's start with that first, and then as a follow-up, you know, what happens if there's a dispute over a deduction? So what happens if I'm a landlord and I don't return the deposit within 14 days?
All right. If I'm a landlord and I don't return the deposit within 14 days, the reason I'm not returning the deposit is because I'm going to say there's damages to the apartment that ate up all the security deposit.
Right.
And so if I'm not returning in 14 days, I'm hoping the landlord's at least sending the letter as to why they're not returning in 14 days.
Right.
And they'll
with
say,
itemized deductions, right? 500
correct.
for the floor, 200 for the cracked window, yada, yada, yada.
Exactly. You have some bad tenants. Exactly. And
We have
then,
some good ones too.
and then what should happen is the tenant should go away because they realize, hey, I partied too hard, I screwed up the apartment, I'm gone, or it's not worth the squeeze. But what may happen is they will sue you. Now, if we're talking about one of your apartments for your clients, that's going to be in Supreme Court because you rent for big money. You're a big time guy. But if you're talking about maybe a smaller apartment that is anywhere under $10,000 a month, they're going to have to go to small claims court.
Right.
And they're going to have to sue landlord at small claims court. And then they're going to have to prove that those damages were not there or that they were reasonable. And that's going to be very tough for a tenant if they haven't taken pictures and taken you up on the inspection.
Right.
And it's just a headache. It's just a headache for everybody. Just treat your apartment nicely. We don't have to deal with this.
It's a headache for everybody. But we literally just had this yesterday where a tenant, we wanted to deduct like $1,500 because for wall damages. And it looked like he adhered something to the wall and just ripped it off. So he pulled off all the paint off the wall. And that's well above, in our opinion, ordinary wear and tear. But he's like, if you deduct, I'm going to sue you. But like, A, is it worth it? And B, you know, what would the penalty be? Like,
you're going to find for most landlords, depending on what it is, it may not be worth it. And that doesn't mean they're not right. They're probably right most of the time, but it just may not be worth it because what happens is you're suing someone, you have to chase them, you have to spend money on legal. Most cases settle, and when they settle, you don't get your legal back.
Right.
And then if you win, you're gonna have to then collect a judgment. If you're talking about $1,500, that judgment's going to include legal.
Right.
You're not going to get all your legal fees over $1,500.
Right.
And then you're going to end up in the hole anyway. When in New York City, by law, you have to paint the apartment, just as an example. You have to paint the apartment every few years and the like. So that's why they have you.
Right.
And that's the best part about having a management team like you or BHS or myself, which is you talk to your team and you say, is this worth it? What's the amount? What can I get back? And then you make the decision.
And how do we work it out? Because otherwise it's just not necessarily going to be. Look, there are cases that I'm sure it's worth it. But
of course,
in a lot of these cases, like, is it worth it? Whoever wins is whoever's most passionate about the case.
I can remember a situation where it was a two-family house. And the upstairs was rented out for a while. And it was, regular lease, no smoking, no pets, no anything. The guy never complained. The guy paid his rent. Everything was fine. He left. We went into the apartment. He smoked for 10 years and he must never have opened the window.
All the windows were black.
All the windows, everything was black. The shower had 2 foot places for where he stood in the shower because he never fixed the bathroom. He never cleaned the tub.
Oh, wow.
Right? It was disgusting. Was it worth going after him? That guy doesn't have any money.
Yeah.
That guy, and I just said to the client, I go, look, paint the walls. Hire your cousin, paint the walls, and you're probably going to get a new tub or get those guys, those commercials, right? When they can just put a tub on top of a tub in like 2 minutes.
Yeah.
Do those guys.
Yeah.
Because although the apartment was disgusting,
right,
there's no way this guy was going to have any money to pay for anything. And it was just not worth chasing him. He was a ghost.
Right. Absolutely. All right, y'all, there you have it. Everything you wanted to know and not wanted to know about security deposit releases. Thanks, Josh, for your insight. We appreciate it.
Thanks for having me.
And we'll see you next time.